Delegate Chisholm, you're all prepared?
Yes, ma'am. Always prepared.
You know what? I don't even know why I asked that question. You're absolutely right. I'm sure you are. Ryan, can you cue the flag, please? This meeting is called to order, the Arundel House delegation.
Yes, ma'am. Always prepared.
You know what? I don't even know why I asked that question. You're absolutely right. Okay, and whoever is not muted should be muted. And Delegate Chisholm, if you need to be, you might need to turn down your YouTube in the background.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And colleagues, you can bow your heads. Dear Lord, we come to you as individuals in your image, but also as one. Let us do what you ask us to do and serve others before we serve ourselves. With knowledge in our minds, love in our hearts, and compassion in our souls, we ask this in your name. Amen.
Thank you, Delegate Chisholm. Good morning, everyone. It's Friday, and we are in a good position, looking good. Got about 30 something odd days left. Actually, today, what, the 12th? So we've got almost exactly 30 days left. Yay, after today. All right, I won't have too much energy. It's too early. So let's get started. We're going to go right into our agenda. I am not going to introduce guests at this time because we don't have everyone here, but we do have a quorum, so let's get started with our business. First item is I'm going to turn it over. I'm going to ask to have a presentation from our capital budget committee chairs, co-chairs, and the chair recognizes Delegate Heather Bagnell and Delegate Shanika Henson. Whichever one of you, however you all want to present, that's just fine. Everyone should have gotten a copy of the legislative bond initiative priorities. If you do not have it, please let us know and we'll make sure we'll put it in your email. Okay, Delegate Henson and Delegate Bagnell.
Thank you, Madam Chair. I believe Delegate Bagnell is going to lead the presentation this morning.
Thank you, Delegate Henson. We had a very robust discussion. As we talked about, we tried to sort of mirror what we did last year, which was a tier 1 priorities, things that we definitely wanted funded. Tier 2, which was our stretch. Legacy funding, which were projects that have been sort of in the pipeline, and then other sources. We did take an initial view of the tier 1, tier 2, and legacy based on a number of criteria. If there was structural integrity issues, because obviously that speeds up the timeline, the diversity across the county, the diversity, underrepresented communities or underrepresented parts of the county, as well as whether we have funded previously and the impacts of COVID on some of these nonprofit organizations. Based on our initial review, and all of the projects that had been offered forth did meet the minimum criteria. They did have either they did either own the property or they had a long-term lease. This year we don't have to have the matching funds, so that wasn't a minimum criteria. And then the subcommittee met again, moved some things around, moved some things up in priorities and down in priorities based on trying to make sure that we were representing the entire county, and also on some additional information that we got on the need Delegate Malone did reach out to a couple of the organizations to get more information. Delegate Henson reached out to a couple of the organizations. So this was the final the final tier 1, tier 2 legacy and other projects that the subcommittee evaluated and voted on. And I don't know if we can share the screen. So, everyone has it. You said Delegate.
Everyone has a copy.
Chair Bartlett. Okay.
Yep. And if you don't, just let us know. We'll email you a copy.
Okay. And Delegate Henson, do you want to add on?
No, Madam Chair, that was an accurate recital of the committee's work and the considerations that we took into account and the meetings that we had and how we ranked and prioritized and worked together collaboratively to try to represent the needs of Anne Arundel County and the projects that each of the delegates put in. I want to thank all the committee members for their work on it.
The chair will entertain a motion, and then we can, after the motion, we can have questions. Is there a motion?
So moved. Second.
Okay, it has been moved and seconded. And are there any questions with respect to by the subcommittee? Delegate Dana Jones.
Thank you so much, Chairwoman, and this will just be brief. Thank you very much. I want to thank the subcommittee for doing such amazing work in such trying times. I wanted to just follow up that the community gardens that had been accidentally left off the entire list was in fact put back on to the co-chairs.
Delegate Henson.
Whoever.
Yeah, I'm not aware of that project. I apologize. Co-chair Henson, do you know about that project?
No, I was waiting for some additional information from Delegate Jones on. I know that we were trying to strike some geographic diversity as well and represent the entirety of Anne Arundel County. We have a number of projects from the good capital city and the good District 30A, and making sure that as we strike balance that we are spreading our dollars around evenly to see if there was any room to borrow from any of the existing projects that we have in our district. And I don't know that I got any information about room to borrow from any existing projects, Delegate Jones. If we have information, I do believe it was an oversight that it was not added to the list. I know that when staff went to combine a list for us about all of the projects, that it was our oversight to not notice that the community gardens weren't on there. So again, I do apologize that was just an oversight. But in trying to add the gardens back to the list, it would be then looking at the funds that we have available to us to see. It was a small dollar amount, so I do think it would be room to add it in there. But that money would have to, we were looking to see where we could squeeze that in.
Delegate Jones, I'm sorry, you go ahead.
Thank you so much, Chairwoman. Yes, I had followed up with co-chair, and I just wanted, it did appear to be a clerical error that had been left off the original list that had gone out. And so it was my understanding through conversations on the floor that potentially that clerical error would be dealt with, if you will. So it is a small dollar amount that was submitted on time and was presented originally. So, and for those of you, because we have so much going across our desk, it was for $10,000. It was a small dollar amount. So it was a clerical error that I just wanted to see if it had been addressed. Thank you so much.
Delegate Jones, the chair would entertain a friendly amendment. If you would like to present a friendly amendment, if that is in proper order, Matt, you let me know if it's not in proper order, to allow a friendly amendment to the presented priority list of the legislative bond initiatives.
Sorry, I was waiting for Matt. Yes, I would very much sorry, Matt. Yes, Chairwoman, thank you again. I would like the previously presented community gardens, and I apologize as I don't have my hands on it right now, to be added back onto this to the list, please. Again, that was $10,000, and I can email the entire subcommittee through Sienna additional information to refresh everyone's memory, as we do have so much going across our desks.
Thank you. So we have a motion.
Second.
And we have a second to add a friendly amendment of the community gardens in the amount of $10,000 to our legislative bond initiative priority list in the tier 1 priority projects. Is there any further discussion?
Madam,
Yes, Vice Chair Rogers?
thank you, Madam Chair. Since this is Friday morning, and there's always an opportunity for a little.
You need to go off mute.
Yes, thank you. So it is Friday morning, and I know that we're looking perhaps for a little levity, maybe not, but I was just wondering, as a point of clarification, will we require at least 12 out of 15 votes, and will someone whistle since this kind of came in after the fact, like we do on the House floor when the bond bill initiative is introduced after the, whatever day in session it is?
Well,
Chairwoman,
you're gonna blame it on your senator?
I would take.
This is all levity, Delegate Jones. It was
I know.
It was introduced timely, and so so we're good. We're good. Thank you.
I'll take the whistles. I'll take them anyway. I'm a good sport, but it was submitted on time. But I'll take the whistles.
All right. If we do not have any other comments, questions, or thoughts to be shared, let's go ahead and we will go ahead and start the vote. Delegate Jones. Okay, great. All right. So, Secretary, please call the roll. The question before us is the legislative bond initiative priority list as amended and as presented to us this morning.
Thank you, Madam Chair. Delegate Bagnell,
Yes.
Delegate Barnes, Delegate Carey,
Yes.
Delegate Chang,
Yes.
Delegate Chisholm,
Yes.
Delegate Henson,
Yes.
Delegate Howard, Delegate Jones,
Yes.
Delegate Kipke, Delegate Lehman,
Yes.
Delegate Malone, Delegate Malone. I see his thumbs up. Delegate Pena-Melnick,
Yes.
Delegate Rogers,
Yes.
Delegate Saab, Chairman Bartlett.
Yes.
Madam Chairman, the vote is 11-0 and the motion passes.
Thank you. So we will forward that on to the appropriate committee as our recommendation, and then they will do their magic and let us know what has been approved. Moving on the agenda, we have an amendment which was heard last week on House Bill 901. This is the bill for the Anne Arundel County Hotel tax alteration, distribution of revenue. The amendment would change slightly the allocation. And I believe our counsel, Matt Carpenter, could share the screen and we can have a look at the amendment. And Matt, if you would explain the amendment, please.
Yes, thank you. As we discussed last week, for the hotel tax, 3% of the tax will be allocated to the Annapolis Art and Public Places Commission, 3% to the Arts Council of Anne Arundel County, 17% of Annapolis and Anne Arundel County Conference and Visitor Bureau. And by this amendment, after these distributions have been made, the city of Annapolis shall distribute 3% of this revenue to the Affordable Housing Trust Fund established under a certain article.
Thank you very much. Is there a motion on the amendment?
Can I ask a question real quick?
You can. Can we get a motion in a second and then we can go into questions?
Sure.
Madam Chair?
Yes.
There was a revision to the amendment. Does Matt have the revised version? I apologize. I believe that's the revised version there. Is that the version that we're voting on? I believe that Matt said that after those distributions were made, then the 3% would be made to the Affordable Housing Trust Fund. And the revised version has the 3% coming out at the same time that the other 3% is coming out. It's a small shift in the percentage, but it does make a difference.
So let's clarify, the amendment number that we should be considering is 953425. Is that correct, Delegate Henson?
Yes, move favorable.
Okay, the chair will entertain questions. Delegate Chisholm?
I just want to make sure I got it. So there's 17%, and if you will, these are essentially going to be fenced off funds. So we have 3% that's going to the housing fund first with this amendment, then 3% to the arts, and then another 3% to some. So we have, is it a total of 9% of the 17% that's now being fenced off? The first 3% going to the housing trust fund. Is that correct?
Actually, two things I would like to bring up. One, I did not hear a second on the motion to entertain this amendment. Is there a second?
Second.
Thank you. And now, Delegate Chisholm, the allocation of funds would be 3%, 3%, and 17%. So we've got 3% and 3% and 17%. Okay, so there's 3 allocations, but Delegate Henson or Matt, if you want to explain that further, please.
You say
Doug Henson or myself?
Delegate Henson, what were you just saying?
I was going to say you stated that correctly, Madam Chair.
So Delegate Chisholm, does that answer your question?
But all the funds are essentially coming out of the hotel taxes that are already established, correct? So it's not an increase in taxes, it's just where they're prioritized. Am I correct on that?
That is correct. It is not an increase, it is a reallocation.
Okay.
Yeah.
Thank you, Madam Chair.
And if Delegate Henson or Matt, if you have anything to add to that, please do so.
I just want to clarify, as Delegate Henson stated, this is for the distributions are distributed to the city of Annapolis. They're the same as the other distributions currently in the bill.
Are there any further questions? I'm looking at my digital hands here. Seeing none. Secretary, please call a roll call vote.
On the amendment 953-425-1, Delegate Bagnell,
Yes.
Delegate Barnes, Delegate Carey,
Yes.
Delegate Chang,
Yes.
Delegate Chisholm,
Yes.
Delegate Henson,
Yes.
Delegate Howard, Delegate Jones,
Yes.
Delegate Kipke, Delegate Lehman,
Yes.
Delegate Malone,
Yes.
Delegate Pena Melnick.
Yes, can you hear me?
Yes. Delegate Rogers,
Yes.
Delegate Saab, Chairman Bartlett.
Yes.
Madam Chairman, the vote is 11-0 and the motion passes.
Delegate Chisholm, your hand is raised. I'm assuming that's from the previous discussion.
Yes, Madam Chair, I apologize. I'll bring it down.
Oh, no problem. Thank you.
Madam Chairwoman,
Yes, Delegate Henson.
may I just say thank you for your support on this amendment. You are the sponsor of this bill, and if it wasn't for your support, it wouldn't be possible. Alderman Gay, who chairs our city's Housing and Human Welfare, the Housing and Human Welfare Committee on the Annapolis City Council, is on the line, and he was instrumental in bringing this to our attention and helping us get the correct language and letter of support from the city of Annapolis as well. So I want to thank you for your leadership on this and your support of this amendment. We do appreciate it.
Thank you, Delegate Henson. Any further discussion? I see no further hands, so I am proud to introduce to some and to just say welcome and reintroduce to others. Or the point is that we know our state's attorney. And it's so good to see you. Ann Colt-Litis, our state's attorney, and she's here to share a few words with us today. Thank you so much for being here. Welcome.
Thank you. Thank you. I'm going to apologize in advance. I tried to get a quiet conference room. They're doing construction on the street outside the courthouse, so every once in a while you might hear some drilling. I couldn't go into our conference room because they've taken it over. We have a very big case today, which I'll talk about in just a second. It kind of hit me this morning as I knew I was going to address you about the impact of some of our police reform. It kind of brought it into bear. But I feel really fortunate to be here. I've been doing this kind of work for 32 years. So if you do the math, you can figure out how old I am, which is always shocking when you write it down or you see it in the newspaper. So I feel like I know the criminal justice system. I know what's good with judges and prosecutors and public defenders and police. And, I know that there is a need for accountability for prosecutors' offices, for police departments. And, we are seeing right in front of our faces on our telephones and our computers and on the news, some really shocking examples of excessive force that, makes us want to act, and we should act. But your job is so complex, and I'm sure hearing from lots and lots of people with lots and lots of opinions about what to do. And I do not envy your task in deciding all this, but I would say that take the experts' opinions and listen to them and make substantial steps, but make careful steps when you enact some of these new laws. Last year, I had the privilege and burden to serve on a committee that came up with some 12 recommendations, the Maryland States Attorneys Association Committee on Police and Prosecutorial Reform. And I had an opportunity to share that list with Delegate Henson, Delegate Jones, and Senator Elfreth. And unfortunately, not all of our recommendations made it into the legislation this year, but that's okay. But so I'm going to talk about a couple that did. But, the case that is about to be sentenced today that I was talking about is State versus Joseph Willis. And if you remember I believe it was January, very shocking when 2 of our county officers were shot and nearly killed. It's Detective Scott Bauer and Detective Ian Priest. And as you consider some of these bills about search warrants and traffic stops and what an officer should do, I want you to think about what these guys went through, because it kind of hit me in the face this morning. They weren't serving a search warrant in the middle of the night, right? They weren't doing a no-knock warrant. They weren't walking up to a vehicle that they pulled over and got ambushed. They were literally following a car that was stolen from a deceased victim. And they followed it for a short ways. At one point, one officer put on his lights and siren, and they weren't even close, really, to the suspect vehicle before the suspect opened fire on them. And one officer, Officer Bauer, was shot in the face. Now, incredibly, that's not even the worst of the injuries that were suffered, being shot in the face. He was able to make a radio call, but he couldn't say what happened to him. He had to text his fellow officers that he was shot, and he somehow managed to drive a couple blocks into a Royal Farm store parking lot before the ambulances could get to him. The second officer, Detective Priest, continued following this vehicle, by now realizing this person is willing to shoot police. This must be the suspect in a homicide because he has the deceased victim's vehicle. And as he approached the vehicle and tried to block the vehicle from escaping, he was shot also. This time, he was shot in the arm, grazed his abdomen, and missed his head by just an inch or so, because a bullet was later found lodged in the headrest. Just a miracle that this officer survived this. And his arm was severely damaged. He almost lost it. It was almost amputated. He had reconstructive surgery And again, worse injuries, believe it or not, than being shot in the face, the other officer. So they've both been out for more than a year, and they're about to be upstairs to face the man who tried to kill them. And this man later told the police when he was arrested and Mirandized after 16 hours after a manhunt, and he secreted himself in a friend's home nearby after he escaped the police chase, that he had nothing to lose because he knew that he had killed his friend while his friend was asleep. He killed him in his bed. That if the police came after him, he made a split-second decision when the lights and siren went on that he was going to shoot his way out of this. And that split-second decision came to Mr. Willis when he was being pursued by the police. And he made that judgment call. And our officers are making these judgment calls all the time and have to make these split-second decisions, life or death decisions, to move their head out of the way so they don't get shot in the head and the headrest takes the bullet. So I just tell you this because officers are brought into very, very dangerous situations every day, more than we can even contemplate. And we expect a lot from them. We expect professionalism, appropriate force. We expect them to be highly trained and ready and able to put themselves on the line to save us. So I always keep that in mind when I have to deal with what they do. These quick decisions that the officers make are leading us to make some decisions about how they ought to make their decisions going forward. And I think the number one priority is, well, there's two priorities. One is appropriate training and spending the money on officers so that they know what they're doing, so that they know how to be professional and skilled and knowledgeable. I think I once read that it costs about $10,000 per officer to properly train them to be what we want them to be, to exercise restraint. I don't know if we spend $10,000 per officer on this. I don't know if we do or not, but it seems like we need to invest in that. The second and most important, and something that really hasn't made it into our legislation this year that I've seen, except for maybe Bill 671 with the Giglio standards. If you want to hold police accountable, the number one way that I see it is that you make sure that police departments are disclosing to their prosecutors' offices all instances of bias complaints, excessive force, dishonesty, all suspensions, any crimes that are charged against the officers. And the reason I say that is when you disclose it to us, when you make the police disclose to us what's going on in their force, which, by the way, we are obligated as knowing anyway. The law presumes that we know what the police departments know. If you disclose it to us, we must disclose it to defense attorneys and to defendants. And when we know what they know, then the courts make a decision. Will that evidence come in against the police officer during the criminal trial, or will it not come in? And so it's not just mere allegations in a internal affairs report. It's not mere allegations in a personnel record. It's evidence of bias, evidence of dishonesty, evidence of excessive force. And a judge weighs what is the value and the persuasiveness and the weight of this evidence, and should it come in against the police officer. And I would tell you that that is the number one way to hold officers accountable. When you shine a light and you make it disclosable in that arena, in a fair opportunity to be heard courtroom. All the other things that we're proposing now can help as well, but I think that this is the strongest way to make sure that kind of evidence comes to light. You're talking about warrants in some of your legislation. We need to step back just a moment and think about what a warrant is. A warrant is the gold standard that we want our officers to get. We want them to seek warrants. We want them to seek judicial approval from a judge to go into somebody's home or someone's business. So if they're able to come up with facts that get to the level of probable cause, we should give them some credit for that because they're doing what we want them to do. And so when we're putting these extra burdens on warrants, we need to be careful that they're not so burdensome that officers say, you know, it's not worth it to get this warrant. I'll just say there's exigent circumstances, or I'll just try and get a consent, right? We want that warrant. We want to encourage that. One thing I'll say about some of the legislation I've seen the clear and convincing standard put in some of the language. Clear and convincing standard is such a high standard when it comes to a warrant. It's not probable cause, it's above probable cause, it's below beyond a reasonable doubt. Clear and convincing evidence is evidence that you have to use in court to take someone's child away from them permanently. So that's pretty high burden. I don't know if we can always get to clear and convincing evidence. Clear and convincing evidence used to be the burden to prove in a death penalty case that there were aggravating factors that should lean towards the death penalty. Again, very high standard, not one that we normally see or use a lot in criminal law. We use probable cause. I would caution you on some of the time restrictions, but that's about all I'll say. I think the Senate's bill is a little bit broader than the House bill on that. And the no-knock warrants, the one thing I can say about no-knock warrants is they ought to be used sparingly. I agree, but they should have judicial review, and they should probably have state's attorney's review to make sure that they are not being used in an improper way. Body-worn cameras. I actually have an Excel sheet if anybody wants me to send it to them or share it with you today during our discussion. As you look at body-worn camera legislation, which the Maryland State's Attorneys Association completely supports, please remember that you also have to recognize that prosecutors' offices need to be funded. For every 100 officers on the street, you need at least one paralegal or clerical staff to be able to process the body-worn camera, because all that camera comes in as raw footage and someone has to watch it and disclose it to the defendant and to the defense attorneys. They have to shield victims' telephone numbers, where they work, where they go to school, their addresses. They have to shield bystanders or confidential informants, and they have to process all that to protect the public before they release it to the defendant and the defense attorney. So for example, with our July 1 budget, the state's attorney's office will eventually be spending $500,000 to $600,000 per year on 8 paralegals and 1 attorney to run our body-worn camera unit for Anne Arundel County Police Department's body-worn camera program. 1 person for every 100 sworn officers, and there's about an estimated 775 sworn officers that will have body-worn camera in Anne Arundel County. And all of that information has to be run through highly sophisticated software. It has to be redacted, and it has to be reduced, and then it has to be packaged, and it has to be sent to the defense attorney, all within 30 days of arrest. So as you look at your other counties, which don't have funding, don't have body-worn cameras, please keep in mind that if you mandate body-worn cameras, that we also need to provide for state's attorney's offices to be able to process it. The personnel records, making certain allegations against police officers public information. I agree that there should be change with personnel records and what's available. However, I would caution you that mere allegations against an officer probably are not the standard that you're going to want to see. You're going to want to see a little bit more than a mere allegation. And the reason why is you could have a very important case coming up. And if a defendant wants to tank that officer or target that officer, they could have someone else make a complaint that this officer's lied or is dishonest or is biased. And then that evidence comes in the trial without any indicia of reliability, without any testing. Is it true? Is it verifiable? So what happens now in court, if there's an allegation that someone wants to use against an officer, there's a weighing by a judge. The impact of the evidence, the reliability of the impacts, the relevance of the evidence, and someone actually makes a determination, is this information that appears on its face at least to be reliable and not the result of some mischief by somebody who's using it to affect the outcome of the case. That's about all I have in my prepared remarks. You know, I have been looking at the materials, and I've looked at all the Senate bills, and I've looked at the House bills. And last night on my way home, my head was going to explode with all the information. So I don't envy your jobs. It is a very big undertaking that you're doing, and I applaud you for it. And I'm ready to answer any questions that are not terribly controversial.
Great. Well, thank you. Thank you so much for being here today. And we appreciate that your information and that you have shared with us. I have I see some questions, and I have a few questions of my own for now. And I may have more later, but my first question is with respect to the charging and prosecution of law enforcement. If you have this information, what has been the charging data of law enforcement within Anne Arundel County?
You mean the number of cases?
How many numbers of cases?
Well, I can try and get that for you if you want it for a period of time. I can tell you that we do have a couple cases. We have a case of an officer right now, and it's in the public domain, so I can speak about it. Basically, there was an officer who responded to a house. I think he found a deceased person there, and then the allegation is he went back later and stole items from the home that he had seen when he was there to investigate. So he's being prosecuted. We are currently, that's an Anne Arundel County case. We've also had charges. I know personally from my job, we've had officers who have been charged with serious traffic offenses, things that are incarcerable. We often send those cases out to an independent prosecutor if we know the officer have a close working relationship. It all depends on the facts. And we had an officer charged with some minor traffic charges, but serious in their nature and their appearance. Some of those we keep in-house and some of those we send out. And we currently have an Annapolis police officer who is charged with 4 counts of misconduct for failing to properly investigate sexual assault and rape cases, and then alleged to have hidden his lack of investigation by improperly closing the cases out. So I would say, just as a rough estimate, maybe one or two a year.
Okay, and with that charging, how many are actually prosecuted?
Well, I can tell you anecdotally, if we're charging an officer, we have a good case and we're moving forward.
And so that is most often?
Yes.
Okay.
If it gets to us, it's going forward, right? Because it's such a difficult thing, because you have to prove that someone was not acting in the appropriate scope, because of course officers are allowed to do certain things that you and I aren't allowed to do, right?
Right.
So if they do it, it really is a clear crossing of the line. Now, there are officers, I can tell you this, that there are officers who are investigated every year in the county, Maryland State Police. We had a case a couple years ago where someone was found to have saying, improperly testifying. We reported it to their supervisors, and the person no longer testifies in court and has a desk job, no longer on the street. So we can't control, if we find something improper, what the police department does. We can only control it if it's a crime, if there's a criminal complaint, and then it comes into our hands. But there are officers who are investigated. And I'll give it an example of, if you take your car home and you're not supposed to, right? You're not supposed to take it out of the state, or you use your car improperly. That might be an internal infraction at the police department, but it doesn't rise to the level of a crime. We're informed when there are infractions, or if someone lies. Obviously, if they lie in court, that's super serious. We get involved. If someone lies about their time card, we wouldn't get involved, but we would be notified of it. And then we would have to disclose it for any of those cases where that officer is a witness.
And my last question is, because there's a pattern that I'm trying to pattern of questions I'm trying to get answers to, and how many convictions have there been with respect to those that have been charged, prosecuted? How many convictions have there been?
I'd have to get you that data.
Okay.
But I can tell you what happens. What my experience is, if there is, and this is why I said shining a light when someone has done something improperly. What happens typically is, if someone is caught lying, or there's some bias or dishonesty or a crime, And there's another case, by the way, that someone had possession of child porn. It was a misdemeanor. So they couldn't be fired automatically by the police department, which gets into chiefs should be able to fire people. Because it wasn't a felony, it was not an automatic dismissal. So we prosecuted an officer who had possessed child pornography. He was found guilty, he pled guilty. He can be fired, but he has the right to a trial board. But what typically happens is when we get wind and the police department tells us we have this officer under investigation, and they investigate and they move forward with dismissing the officer for a trial board, what often happens is that officer quits. So it's not necessarily rising to the level of a crime, but it's misconduct in an internal way. And we get wind of it and the officer quits rather than face a trial board.
Okay. Well, thank you very much for answering my questions. And I apologize, members, I'm going to have to put the questions on hold for 1 second because there are two things I have to take care of before we start losing some of our members. As we know, we share our members with the Prince George's County delegation. And there's one technical thing we want to take care of. With respect to House Bill 901, I did not hear a motion on the bill as amended. Is there a motion on the bill as amended?
So moved.
Is there a second?
Second.
And are there any questions? And you would need to do your physical hand because I've got the virtual hands in line for questions for the state's attorney. Okay. Seeing no questions or discussion, Secretary, please do a roll call vote. This is on 901 as amended.
On House Bill 901 as amended, Delegate Bagnell,
Yes.
Delegate Barnes, Delegate Carey,
Yes.
Delegate Chang, Delegate Chisholm,
Yes, because it does not increase taxes.
Delegate Henson,
Yes.
Delegate Howard, Delegate Jones,
Yes.
Delegate Kipke,
Yes.
Delegate Lehman, Delegate Lehman,
Yes.
Delegate Malone,
Yes.
Delegate Pena Melnick,
Yes.
Delegate Rogers,
Yes.
Delegate Saab,
Yes.
Chairman Bartlett.
Yes.
Madam Chairman, the vote is 12-0 and the motion passes.
Thank you. And thank you, members, for indulging on that, but we've got to dot our I's and cross our T's. So now let's resume our discussion with Madam State's Attorney. And the first hand I saw was Delegate Mike Malone.
Good morning, Madam State's Attorney. First of all, I want to commend you for seeking justice for those two officers that you described that are having a sentencing hearing today. It certainly is important to support our men in blue. I also want to commend you for some of the little things that your office does. During the pandemic, a lot of trial dates have been kicked out. You know, I don't do a lot of criminal work, but I do some. And sometimes defendants actually need a faster date or attention faster because maybe the charge is appropriate to be steaded or null-prossed. And I want to commend Brian Marsh and Jessica Daigle in your office. I had a couple matters that needed attention faster than a trial date, and they were very good at getting back to me. May have saved a gentleman who had a clearance and saved his family and maybe kept his family from becoming homeless because he may have lost his clearance without the prompt attention in the matter. So thank you for that. I also thank you for your concerns regarding search warrants. I can assure you that yesterday on the House floor, I very much expressed many of those concerns that you just expressed regarding the clear and convincing standard and what a bump that is regarding the timing of the service of search warrants. So I will continue to address that as we go forward with the legislation. But lastly, the question I have for you is on the body cams. I've also expressed the concerns about the cost, and not only to the police force to provide the body cams, but to the state's attorney's office. I've had a conversation with Scott Schellenberger, and he said it would cost, I believe, annually $2.3 million for his office. And you mentioned 500, 600,000, and then 700 officers. Do you have a ballpark what the annual cost would be for your office to be able to review and process the body cam data to be in compliance with Brady and the other requirements?
I do, and I actually have if you want me to send it to you by email or share it with you now, we have actually done it, and it's been approved by the county council budget. The reason why our costs are not as high as Mr. Schellenberger's is we have office space, and we're about to share office space with members of the police department. The judiciary is moving out of the Maryland Judiciary Center over on Bestgate Road, so we have free office space, and we have the county already gives us computers, so they don't factor that in, and we have this free office space, so that's why our costs are about 500 to 600,000 per year. And it's paralegals we're using. I guess our costs are a little bit less than Baltimore County. 1 attorney, 8 paralegals to run the unit.
Thank you very much.
Mm-hmm.
And I yield, Madam Chair.
Thank you, Delegate Malone. Delegate Chisholm has a question or comment.
Thank you, Madam Chair. Yes, mine's more of a comment. I just wanted to thank you, State's Attorney Leitis, for bringing up the 2 officers. That was in Delegate Kipke and I's district when it finished. It was a scary time. They took a while before they could search and find the shooter. And my prayers, and I know yours, you're doing everything you can to bring this to justice, because what those families went through and what these officers went through was horrific. And I thank you for all your service to the community and what you're doing in this case and other cases. And I think the words that you shared early on in your testimony were invaluable. And I certainly appreciate everything you said. Somebody that's dealing with it every day, your words need to be heard and considered at all times. So thank you very much for that. That's all I wanted to say, Madam Chair.
Thank you.
Thank you, Delegate Chisholm. Delegate Henson.
Thank you, Madam Chair. Thank you, Madam State's Attorney, for your wealth of knowledge. I feel like we are so lucky to get to be able to pick your brain about these things. And I'm thankful that you gave an audience to myself, Senator Elfreth, and Delegate Jones in the interim, so that we could consult you before we had to make important decisions and get to make them from the benefit of being informed by your expertise on the issues surrounding law enforcement officers, police accountability, and transparency. Since we've put those bills to rest, I wanted to ask about some things that constituents have been asking us about, and then one more policy area that we have yet to explore. When we're having the conversation on the efficacy of school resource officers, in my mind, one of the only ways that makes sense is if the mission of our juvenile court system is actually living up to what it's supposed to do. And that's if our juvenile court system, if juveniles are deemed delinquent, and then the court system is curing their delinquency through a series of services that they're providing to the juveniles that are even reaching into the families to allow those juveniles to then get on the right road and to, get better treatment and things of that nature. If it's not designed to be punitive, but to help the juveniles and the families, then in my mind, I could see some value if we had properly trained SROs, if we were, and rooting out implicit biases, if we could, kind of get rid of all those negative things that we hear about, and we could get juveniles who needed help connected with help, and that being designed through the juvenile justice process, then I could kind of see some pathway forward where it could be valuable for our students. But I wanted to know, in your estimation as the state's attorney, how close are we hitting the mark with our juvenile justice system to being that resource and service provider?
Well, juvenile justice, we could talk about for days, and it's extremely complex, but what I'm seeing is the numbers are way, way down. And by the time we actually see a juvenile in our courthouse, that young man or young woman has committed 3, 4, 5, 6 crimes. Because what's happening is those crimes are dealt with in a more informal way. And then by the time they get to us, it's kind of out of control. We see 2 kinds of crimes right now. Currently, the snapshot of our lives right here. We have traffic. Someone takes mom or dad's car. maybe drunk driving or drug driving. So not terribly bad. And then over here, we have armed robbery or sexual assault or very, very bad assault. So what I see the problem is that we really aren't spending the money on the juveniles. By the time a juvenile is sent to a rehabilitative place, a juvenile center that's supposed to help with schooling and behavior, that young person is sort of almost like a last chance to help. And we're not spending the money in the beginning, in my humble opinion. We're not investing in kids at the beginning. And the money, the resources, if you can imagine, to send somebody to one of these places is like $50,000, $60,000, $70,000 a year, right? It's a lot of money. Imagine if we took that money and helped young people when they're first starting to get into trouble, right? So what happens in the juvenile justice system is, say that your house is burglarized by your next door neighbor, the juvenile, right? The cases try to be resolved on an informal basis, maybe pay some restitution, maybe the child goes to, you know, some activity. And the state's attorney's office never sees it. The only time we see it is if the victim doesn't get their restitution or the victim complains and the case comes up to us. But there's not really that intervention, not the intervention that you would think that we would give to that juvenile, because if a juvenile is burglarizing their neighbor's house, there's some problems going on. And I don't see the services really being concentrated. So if you want to do good things, let's give those folks in the juvenile justice system the tools and the money to help that early intervention. I wholeheartedly agree. I feel strongly about school resource officers. If kids in a high school know to trust that officer, they will go and they will talk to that officer and tell them about a problem. That officer hears whatever the rumors or the gossip are. School resource officers stop people from bringing guns into the school. You know, one child will walk up and say to the officer, you know, I heard that so-and-so is bringing a gun, or there's a gun in their locker, or there's a gun in their backpack. And that's how these things come out. It's not about punitive, it's really about safety, making that school a safe place, and having an ear to the floor of what's going on. I agree with you that there have been some statistics that are shocking and alarming at how the disparity of treating people of different races is. Suspending people of color versus Caucasians, that's shocking. There's mistreatment. Obviously, we need to fix that. But the school resource officers are someone versus the police being called separately for separate instances in the school. So I think that school resource officers are very valuable. I hope you'll have a chance to talk to some of them yourself to hear what it is. But I think what they do is they are a friendly face that can be reached out to, versus the idea of that they are, you know, the law that's putting down the hammer in the school. I think they're keeping the peace. I really do. And I think that because they know the students, they know what's going on, they know the principal and the teachers, they can develop a rapport. They can call the crisis intervention team, which, by the way, underfunded in the county. That group should be 10 times the size it is, because those are the folks that are responding to juveniles in crisis. And quite honestly, that's what I'm trying to do right now. I'm trying to hire social workers to embed with the crisis intervention team for juveniles. And I hired a social worker to help with juveniles as well. So I think that the early intervention, whether you get the word at the school or in the juvenile justice system, let's spend our time and resources there. By the time they're coming to us in court, we went from, I don't know, 800 cases a year to 300 cases a year. And that's because we're just not seeing the cases until it's really, really far along.
I think I understand. I think we build our systems based on what we presume kind of the next link in the chain is doing. And we presume that when a juvenile is in court, that they're being connected with services so that they can be treated to cure the delinquency. And it sounds like there's a little bit of disconnect, that they're not necessarily getting all those services, that we're thinking that there's some intervention that's happening. And then only the most severe cases are coming to court. And by the time they come to court, it's not necessarily that opportunity for all the services and treatment that we are then building our policy about the next step, presuming that they've had the opportunity for.
That's exactly right. And let me tell you, I started in juvenile court as a prosecutor, and we had a lot of cases, which would be shocking if you just looked at the number like, oh my gosh, what are all these kids doing here? But the way it was different is the juvenile magistrates now, they used to be called masters, would sort of have a personal relationship with the child, a personal accountability. And they would have the child come back for review. How are you doing? Are you in school? And the master would sort of make everybody do their job, right? They would make the social worker come and do a report. They would make, the parent come. What are you doing, parent? Are you in treatment if you need it? They would get a report from the school. They would get a report from the probation agent. And they would make everybody do what they were supposed to do. That's not happening anymore. What's happening now is lower level people are screening the case out. Oh, it's your first burglary? It's your first assault at school. If you bring kids, to a place and they're held accountable and they're supported and services come in right then, right? A whole group of services come in, I think it's a better outcome. But I think that there's this perception that it's awful to bring kids to juvenile court. But I can tell you, the kids are not going to be detained, right? If they're not going to be held when they're coming to court, but they will see somebody who will talk to them and who will make sure that everybody else is doing what they're supposed to do to serve the juvenile.
Thank you for your perspective. If Madam Chair will permit me one additional quick question.
Very briefly, I know that Madam State's Attorney has a hard stop at 9, and we still have one more person who has a question.
I wanted to ask about victims and witnesses in our system. I know that the family of Tyreek Hudson, when they traveled here from North Carolina, that they had expressed a lot about their experience in our court system. And then we recently had a case where there was an assault that happened that was really high profile in Annapolis of a young man, and it was some retaliation. And the witnesses that turned out to court for that, the case wound up being dismissed. I know you can't comment on any individual case, but the treatment that our victims and our witnesses have had by the state's attorney's office here in Anne Arundel County, we get mixed reviews on people feeling as though they have had an opportunity to be informed and be engaged in the process. Is your office, do you have any changes that you've thought about implementing, or what are your impressions on how victims and witnesses are ushered through the process there by the office?
Well, the Tyreek Hudson case is the quintessential example of no one is going to be happy, pleased, everybody's going to be miserable, and we're all going to be crying and in the courtroom and afterwards. The Tyreek Hudson case, the family was informed a year before he pled guilty, the defendant pled guilty, that he was mentally ill. About 8 months before the guilty plea, the doctor said, this man is mentally ill and he was not criminally responsible. And we have, I can share this with you privately later, emails, phone calls, things of that nature. It is one of those things that it was so excruciating for the family that they didn't want to say that, yes, we talked to them along the way, we emailed them, we had conference calls. It was so exquisitely painful because how does anybody get straight in their mind this insanity of killing a 22-year-old young man on the verge of his life? It makes no sense to anybody. And the pain is real. And I can tell you, as dealing with people who are traumatized people are not going to come in and say, this was a great experience. They're just not. We were aware of it, acutely aware of it all along. What exacerbated that situation is, a judge who forgot that he was going to allow the doctor to testify, who was angry and upset about the situation of people protesting. And I mean, it was one of those things that if it could go wrong, it would go wrong. I even have emails from mom and dad about thanking us for what we did. In fact, we coordinated their travel from North Carolina and New York. So we're always ready to take criticism. I'm used to criticism. But what I've found in this job is sometimes you're criticized even when you do everything right. But we will do everything we can to respond to victims. Our door is always open. We have a head of victim witness who we help people relocate who are threatened. The two folks who had that, somebody disclosed a video of them talking about a murder in Annapolis and what they knew. We reached out to their lawyers. We continue a dialogue with their lawyers, trying to help those folks relocate. We've offered them services as we can. Sometimes people say no to the services we offer, but we are very responsive to that. And the Maryland State's Attorneys Association also helps us relocate witnesses if they are in fear for their lives. But thank you, Delegate Henson. And if you want me to share any of that information with you privately, I can.
Thank you, Attorney. Thank you, Madam Chair.
Sure. Do you have time for one quick question?
Sure. I have my colleague is up in court and he's going to do the preliminary part of the case. So I'm fine.
Okay. Delegate Bagnell.
Thank you, Madam Chair, and thank you, Attorney Nanko-Latest, for being here today. I actually wanted to ask something a little different because I know that you've been working on the expansion of the drug courts and diversion programs, and you know I absolutely agree about the incredible work that our crisis intervention team does. But during COVID, we have seen another spike in our overdose rates and our usage rates. So can you talk just briefly about the work of the intervention of the drug courts to get people back into treatment programs, and if you have seen an adverse impact from COVID, from the reduction of the court system and the challenges with just trying to get people in that coordination of care.
I think the pandemic has made it so difficult for people who are in drug court to have that face time with the judge and with the counselors, right? Because like I was saying in the juvenile system, if a person comes before the court and someone cares about you and is monitoring your progress and making sure you're doing, kind of holding you accountable for what you're doing and your actions, it's extremely valuable. And the pandemic, we haven't had that. So, and at the same time, the courts are talking about cutting funding for, we are partially funded for drug courts for our paralegals, and part of our attorneys are paid for that. We have people who are dedicated, who that's all they do full time. We have, I'm guesstimating about 6 people who work full time on the drug court. So it's just kind of getting back into the flow and making sure people have the opportunities. Again, the waiting lists are sometimes high for outpatient, which is the #1 form of drug treatment that's used. And we do offer diversion and drug court. So diversion is when it's on a lower level, and drug court is when someone is committing serious crimes and we're trying to keep them from being incarcerated by being in a program. So diversion is if you have a simple possession. Drug court tends to be when you're committing crimes.
Thank you, Madam.
Thank you, Delegate Bagnall. And thank you, Madam State's Attorney, for being here today and answering our questions and providing information to us. We will keep the lines of communication open. We have much work ahead of us. The Senate has passed their version of the police reform and accountability, and the House has passed our version, and we have to have the versions the same. So there will be further discussion. And so we thank you for your presentation and the work that you do in all your public service. Thank you for being here this morning.
Thank you so much for inviting me, and I look forward to talking to you. And if any of you have any questions of me offline, my personal phone number is 410-222.
Wait, Madam State's Attorney, this
Yeah.
is this is live. Do you want everyone to have the state?
Oh, okay.
Okay.
Well, I sent you an email this morning to everybody. You have my direct line. Yes. And if you can't get me, my assistant Sharon Jones will get me.
Great.
Thank
Thank
you.
you. All
Bye-bye.
righty. Take care. Whew, that was close. Okay. All righty. So we have some guests who have joined us that I want to make sure that I acknowledge that they either were here or are still here. We did have Alderman Dewan Gay from the city of Annapolis joined us, and we had Senator Sarah Elfreth is here, and good to see the good senator. Okay, moving along to our next guest. Ms. Tamika Perkins is the Director of Juvenile and Victims Assistance with Anne Arundel County Police. And we thank you for your patience in waiting so that we can finish that discussion. And we welcome you here today. Thank you very much. And some of the questions that we asked with respect to juveniles, perhaps you can help us with that as well. So Ms. Perkins, whenever you're ready.
Good morning, everyone. I just want to acknowledge also on the call, I have my side partner, Corporal Michelle Levere, who is also of the Juvenile Victim Assistance Unit. And I want to change around some of the talking points that we were going to speak about, because I just want to address some of the questions that Delegate Henson had regarding juvenile justice services, as well as our school resource officers. So I just want to give you a little bit of background about the Juvenile Victim Assistance Unit. The justice system that State's Attorney Leitis was talking about was the system directly prior to the State's Attorney level. That would be the Department of Juvenile Services. We take a different approach here in Arundel County than they do anywhere else in the state with our what we call frontline diversion programs. And so basically, we divert youth out of the system at the time of arrest or citation and even prior. And that is the level with which we offer services, mentorship, non-punitive interventions. And we're going to talk about that a little bit today, both what we currently do and the direction that we're heading in. I'm not sure, is it possible for me to share my screen?
It is possible. Staff, can you please make Director Perkins a co-host?
I also want to let you all know about an initiative that we currently have with the police department. It's our Minority Youth Advisory Council. This was created in the wake of George Floyd's death and the subsequent conversations between police and community. We wanted to make sure that our underrepresented voices were heard. Our youth, specifically 14 to 18, and we wanted to make sure that we had countywide representation. And so once a month, soon to be once a week, we will be bringing those youth alongside with law enforcement, either at the patrol or at the command level, to have conversations about social justice, about equity, about programming, about restorative justice, and making sure that voices are heard on topics that matter to the youth. And so a lot of the presentation that I'm going to give you guys today reflects their words. And I was also told, because we had our meeting last night, that please invite anyone on this call if they would like to join in a Minority Youth Advisory Council meeting. That you all are more than welcome at Thursday evenings between 5 and 7. I want to let you guys know about our youth diversion program. So we currently have 3 in Anne Arundel County, and this is prior to a case being referred to the Department of Juvenile Services. This is prior to the juvenile having any record with the court system or the Department of Juvenile Services. We have these partnerships with the Naval Academy, because if you go through one of our diversion programs, you are still eligible for top secret clearance. And what that means, what those diversion programs are, is our teen court program, our joins program, and our community conferencing program. Our community conferencing program is a restorative justice program where parties involved will meet with a trained facilitator to have similar to a mediation process. This can happen either before or after a citation or arrest is made, but this would be for some of those conflicts, like the state's attorney talked about, your burglaries, your destruction of property, your neighbor disputes. We do this in a lot of cases of bullying or harassment that it would be an ongoing issue. It may not rise to the level of charges, but it's still something that we need to resolve. We also have our teen court program and our joins program. And I wanted to talk about those because the goal of those programs is to get to the why. So prior to entering any of those programs, you would have the family and the youth would have a meeting with both myself and Corporal Levere, and there's sometimes a third member of the panel, and we want to get to the heart of the issue. What's going on at home? What's going on at school? Is there any history of mental health or trauma? Are there any changes that may have triggered this offense? What happened with this particular offense? From there, we assign what we call meaningful interventions. So this could be counseling. This could be linkage to our crisis intervention team. This could be drug screens, community service. And when I say community service, I don't mean picking up trash on the side of the road or anything like that. This would be working within their neighborhood to do something for their neighborhood that only they can do. So it could be, for example, we had youth who were breaking into a gym because during the pandemic there was nothing for them to do. They were bored, but they also are welders and woodworkers. And so their community services, they're going to be building basketball hoops and toys that will be distributed through our youth activities program. And they also had to do their community service with the church that they broke into, because that's the way that we would like to repair the harm. We follow these youth for 90 to 60 days to make sure that they have the services that they need, to make sure that they are engaged with the community, that they feel supported. And we also offer the parent services as well. So this is the whole family kind of wraparound. One thing I want to say about this program as well is that this is a unique program in that it is universal screening. So in Anne Arundel County, all juvenile cases have a single point of entry, which allows us to screen them all at once, meaning that we're not dependent on referrals for our diversion programs. What we've seen at the national level is referral-based diversion actually exacerbates the racial and ethnic disparities that we see at other entrance points in the justice system. We do not have that in Anne Arundel County. So we actually divert minority youth at the same proportion with which they are charged. And we're very, very proud of that. Other jurisdictions are coming to us to talk about our screening process. Additionally, our success rates, I'm so proud of. So for any of our programs, over 85% of youth who complete our programs do not have any additional law enforcement contact within the year. And we're very, very proud of that. What we are looking at doing now is pushing that back a step so that we have officers refer youth to this program before a citation is written, before a charge is filed. And so we want to even not only address the record behind it, but address the stigma. I'm a huge proponent of labeling theory. If someone identifies you with a label, be it a criminal charge, then I believe that can impact you psychologically. And so we are switching to pre-arrest diversion, both at the patrol level, but we are also looking forward to doing it in the schools. So this would be a civilian sworn partnership similar to a crisis intervention team, except the civilian would be a case manager level instead of a clinician. And we call it Project Fresh Start. START stands for Safety, Trauma-Informed, Accountable, Restorative, and Transparent. And this is designed to be a universal response to low-level offenses where we can decriminalize the behavior, still hold the youth accountable, but also link them to services. Because of the universal screening, what we know from our our current diversion efforts is that universal screening is going to intentionally reduce the racial and ethnic disparities that we see at various points in the justice system. We had a conversation with our Minority Youth Advisory Council specifically about school resource officers and some of the legislation about removing them from the school system. And we polled them anonymously, and none of them were in support, even after having a conversation about the school to prison pipeline. I have to say that. And we had a conversation with them about that. And we asked them, is this an all or nothing thing? Do we have to, are there are only two options, removal of SROs or the continuance of the school to prison pipeline? And they were not in support of removal of school resource officers at this time, even those who had negative experiences once we discussed the benefits as well as the Fresh Start project. So what this would look like in a school setting would be an SRO is notified of a chargeable offense. The SRO would talk to we call them the START coordinator, as well as administration. They would determine whether or not this is a START eligible offense. If it's not, then the case would be handled accordingly. Once victim consent is received, it would be an automatic referral to the START project, at which time the SRO and the START coordinator would sit down with this youth and the family. They would have a conversation about similar to the intake that we currently do, about mental health, about trauma, about, what happened to this, what happened in this particular incident. We would have conversations about the young person's goals, about what's going on at home, how are they doing at school, what are they looking for in the future. And from there, we would all work together to create these meaningful interventions that we talked about. This could include community conferencing and restorative justice program, as well as a referral to our crisis intervention team for more severe mental health and substance abuse needs. We have already started piloting this program at the patrol level. And what we've seen is in the one district that we're piloting it, it has reduced the charges for that district in half. And we anticipate that it would have similar success as far as recidivism rates to our current diversion efforts. Additional recommendations that the students had that we've taken into consideration as a department regarding their school resource officers would be a uniform change to a softer uniform. That is something that is in the works for both this school year as well as next school year. The opportunity or the option to switch to a blue polo style shirt and khaki style pants versus the traditional uniform. The students also requested that SROs be required to introduce themselves to students in the beginning of the year and to discuss their role. They would like more SRO classroom time, explaining their rights, the laws, that kind of thing. And we've already started doing that. As a unit, we've partnered with Arundel High School as well as various school system and initiatives. And in addition to us being there, we're engaging the SROs in that as well. One thing that they really harped on is that we want to ensure that the officer is a good fit for the SRO program as well as the school. We've modified the interview process for school resource officers. Myself, who has a background in equity studies as well as social work as a civilian, now have the opportunity to work with SRO supervision to be a part of that interview process to make sure that we really do have good SRO fit for the schools. Students also requested that we publicize the complaint process of who they can contact if there is an issue with the school resource officer. And then they would like us to continue to work on reducing the charges and continuing to train. And those are things that we had already started working on. Our SROs are some of the most highly trained SROs in the state and in the country. So in addition to the mandated 40-hour requirements by the state, our SROs are also trained in mental health first aid, youth mental health first aid. They are mostly crisis intervention trained. They will all be crisis intervention trained by next school year if the pandemic has had an impact on that. But they also receive Anne Arundel County specific training with myself. So this particular school year, at least twice a year. The most recent training for them was on the trauma of COVID, the trauma of racism and discrimination, the way that the national narrative will impact their jobs when the students return to school. And it actually resulted in us creating action items that SROs can do to be more trauma informed in dealing with the school or students when they return to school.
Director Perkins, I'm sorry to interrupt you, but I want to make sure we have time for questions. You have provided us with excellent information, and I want to know, we did set it up so you could share your screen, but here's the thing, could you possibly share what you were going to share with us in an email? Because this information you are sharing is super helpful and would be wonderful. I know our constituents would love to know more about the SRO program and what the, what has been the result and what have been the student recommendations. I think it's super helpful. And I would love that if you could share that with us as well. That would be wonderful. Is that a possibility?
Absolutely, ma'am. That is possible. And if I can just share one more thing before we
Please
go
do.
to questions.
Yes.
We were very proactive about this, recognizing some of the increases in charging that everyone is aware of. And even when accounting for COVID, with our efforts, our training efforts, and this is excluding any diversion efforts, we saw an over 22% reduction, even when accounting for COVID closures, in our school-based charging, just based on half of the program that we just described in a year. And that is without any additional increases in racial and ethnic disparities. Our racial and ethnic disparities are also going in the right direction. I also wanted to point out that with our diversion programs, we are diverting approximately 600 youth out of the system every year, and through the programs that I described. And we're very, very proud of that because we are a very, very small unit. It's just us. And so we're very, very proud of the work that we put out. And we don't do a very good job of communicating it because we are so busy, but I want to make sure that you guys have that information. So thank you so much.
Thank you very much. I have one quick thing I wanted to bring up, and that is Arundel County in the MSDE report, I believe it was school year 2018 to 2019. I believe that's the last one that I saw. Arundel County had the most arrests. I think it was 346 in the school system. And I don't know if you can answer this question, and or if maybe Corporal Lavera can answer. What is the arrest of lack of respect? I saw that listed as one of the items that students had been arrested for. And I just would love to know what that means. If you don't know, that's okay. But
I'm going to let Corporal Lavere do that, answer that question.
I would certainly appreciate that. Thank you very much.
Good morning, man. Thank you so much. So for the MSDE report, the lack of respect can fall into a variety of categories. More or less what you see there is going to be your disorderly conduct or disruption of school functions. Essentially, that particular charge is usually coupled with a variety of other charges, usually an affray, which would be a assault or a fight in school, would be the charges you most frequently see with that, because it's diverting all the time and attention away from the general school activities and focusing singularly on that one particular incident. So that's particularly what you're going to see there. It's not a charge that you typically see as a standalone charge, but it definitely is one that we're looking into. There is some legislation coming now for us not being able to charge for that particular incident in and of itself, if that answers your question.
Yes, it does. Thank you, Corporal. I appreciate that. And thank you, Director Perkins. We have some other questions. The Vice Chair.
Thank you, Madam Chair. Ms. Perkins, I too would like to just sort of piggyback off of Chairwoman Bartlett's request for the information, and I look forward to seeing that. And in particular, I'd be interested in seeing the statistics based on your presentation, any changes in terms of the the citations received from students like from, Meade High School or North County or Annapolis to see if see what that improvement actually looks like. So thank you very much.
So I can give you, I can't give you the exact numbers, but Annapolis High School, we're looking at over a 20% reduction between 2 school years, and Meade High School, I believe it is closer to 30% reduction, but I can certainly get you those numbers. Yes, sir.
Yes, I was actually very pleased as well when I saw that report that the numbers were going down for Meade High School. So thank you there for your good work that you all are doing. Delegate Henson.
Thank you, Madam Chair, and thank you, Ms. Perkins and Corporal Lavere for your presentation this morning and for the time you've put into informing us about the work that you're doing. I think that you mentioned at one point, Ms. Perkins, that you are working so hard on this program with limited capacity and resources that it leaves you little time to share the good work that you're doing. And I think everyone that's on this line today can certainly sympathize with being in that position. I wanted to know a little bit more about how students are being referred to your diversion programs. Is it that you have to be arrested or you have to be involved in an incident in school and then you have the opportunity for the services? Or is there any other sort of soft pass off or transition short of that type of incident?
So there's a couple of different ways. So prior to this year, referral to our diversion programs required issuance of a citation. Now those can happen prior to the issuance of a citation, prior to arrest. And so now the referral just happens after a report is initiated by the school resource officer for those specific programs. However, we are very, very big on early intervention and early warning system. I'm also the county's Handle with Care coordinator, and I work very, very closely with Lieutenant Thomas of the crisis intervention team. We also work very closely with the school system on looking at youth who have repeat victimizations, repeat traumatizations, and how we can provide them services before there's any justice system involvement or even, school-based discipline involvement. So we are working on that full continuum. Yes, ma'am.
I also wanted to know how young the services are, what's the age range on your programs. I know that we have a number of students in elementary school ages where if their offense is such that the school feels that it rises to the level of, I don't want to use criminality, but I guess juvenile delinquency. If they don't have an SRO there, they just call the police department that's relevant there to the school. Do you all provide services for elementary students, or is it at the middle and high school level where the SROs would be in the building?
Do you want to answer that?
So, ma'am, to address that particular question, yes, we do offer the same services to the elementary level. It just has to go through a different process because the patrol officer would be notified and responding to the school accordingly. And say a citation is written, we have a very close relationship with all of our districts. I want to say all of our officers because I came from patrol prior to coming to this particular unit. So what happens is if a citation is written, every citation that is written within the county, also our partnership with Annapolis City, comes across one of our desks. And from that point on, we are looking into any mental health reasons. And also, we have a nice relationship, like I said, with our patrol officers. A lot of conversations happen offline. Even if a citation is written, there are a litany of officers that essentially go to bat for all of the children that they come in contact with. It might be a, delinquent, situation, but the officer understands that there may be some trauma. So we try to address it the best way that we can and getting those early interventions, even if there is a citation. So yes, it is applicable across the board, whether it's elementary, middle, or high.
Thank you. I know that Delegate Bell has done a lot of work in this area. I look forward to an opportunity to meet with both of you offline. I know that in District 30A, we have a lot of juveniles that are in need of. It sounds like the type of services that you're providing. We also have Annapolis City Police Department, and it sounds like you have an existing partnership there. It's such a conflict with trying to extract the parts of the SRO relationship that are valuable and that are good, but trying to make sure that we buff out and leave behind the parts that have disparate treatment and negative consequences and lifelong poor impacts to students of color and to communities that are minority and disadvantaged. So ways that we can try to figure out how to do that. I think that I think I speak for myself and the members that represent District 30A, that we are interested in trying to figure out how to get the valuable parts for those that we represent. So I'm thankful for the time you guys have given us this morning. Thank you, Madam Chair.
Thank you,
And
Delegate.
Delegate Henson, if I
Go ahead.
Sorry, if I can just piggyback to what Corporal Olivier said, that the current way for patrol response to those elementary schools is the issuance of a citation now, with the exception of one district because we were piloting it. But we expect within the next year or so, we will have the pre-arrest option countywide. We're just rolling them out district by district because of staffing levels.
That's great, because I just don't my problem is, what is the effect of being arrested at school amongst your peers, amongst the educators? I just find it interesting that you would be arrested at school in front of your peers for some of the infractions. And Corporal did a great job of explaining that, some of them are an overlap of more serious charges, but I am concerned about the effect of your peers seeing that, and your teachers, because you don't want to be labeled as, you don't want to be labeled.
So I will say, I just want to make sure everyone is aware that the overwhelming majority of what is labeled by both by MSD as well as the county as arrests, the overwhelming majority of those are paper arrests, meaning it's the issuance of a citation, not a physical arrest, where there's, handcuffs, transport to booking and things like that. But I agree, the stigma that is associated with either of them, it has an impact, a lasting impact. And that is why we've been actually working on the START project for a little over a year, coming up with the logistics, looking at what best practices nationwide are. And it is specifically designed to leave the positive, the resource part of SROs, as well as the safety part of SROs, while mitigating that school to prison pipeline. Absolutely.
Great, because some of the things I did when I was a youth, my teachers pulled me aside and talked to me, and it made a big difference. I don't know what it would have been like if I had been charged for the 3-day fight that I was in. Quite frankly, I was in a 3-day fight. So I don't know what that would have resulted. But Delegate Bagnall, this will be our last question from Delegate Bagnall.
Thank you, Madam Chair, and thank you, Director Perkins and Lieutenant Corporal Olivier for being here and giving us your time. I actually am piggybacking a little bit on our chair's question, because when we see these stats, we are just seeing them on paper, and it is very alarming and stark when we see arrest of students. But if you can talk us through a little bit what that actually looks like, and how how the interaction of our SROs does or doesn't result in an actual record. Because I know that you spoke with me about that, but I wanted to have some clarity on that, because my understanding is that the paper arrests don't necessarily result in any sort of record or actually interception with the court system.
So all arrests, either paper or physical, have the potential to result in a record with the court system. I believe what you're referring to is We do, once the citation is written or the physical arrest occurs, at that point, that universal screening for diversion efforts happen here at the police department level prior to it being forwarded to the Department of Juvenile Services or the circuit court. So we actually stop that record with the state from happening because we handle it here through our joins, our teen court, or our community conferencing program. And so completion of those programs does not result in any justice system record, any juvenile record. They do not experience the collateral consequences of that charge as far as impact to employment or scholarship opportunities, student loans, or things like that. And like I said, we diverted approximately 600, on average, between 500 and 600 youth a year. And we're very proud of that. So for those 500 to 600 youth that are diverted, they do not have a record and they do not have those impacts. And what we're, with this implementation of the START project, we're going to take those interventions and that are in our diversion program, and we are going to put them in place prior to issuance of the citation. So we remove both the record as well as the stigma, and it just becomes a accountability, intervention, and service-based program within the school systems as well as on patrol.
Thank you. And if I could just ask one follow-up, what is the time frame for the START program for full implementation, do you think?
Within the school system, so we are currently looking at grant funding because it is, it's just Corporal Levere and I believe that, having START coordinators who assist the SRO would be best served if they are part of the school community as well. And so we're looking at the logistics of that. The START program has already started in one district in patrol. It will roll out in a second district in patrol April 1st. As far as schools, it's my understanding that it will be piloted in a cluster next school year, but I don't have, that is not solidified. As soon as I get the okay and we solidify the funding, then I will definitely come back to you guys and answer that question. But the START program does not replace any of our current diversion efforts. So they're still going to be going on even for the schools that have not piloted or that are not piloting the START program.
Thank you. Thank you, Madam Chair.
We really appreciate having you here today. And it's great to form this relationship with you because we all, in all our districts, we want to do all we can for our youth. Because they will be here in these positions, these very positions that we're in, they will be in these positions one day. So we want to do everything we can to prepare them and to give them opportunity and so that they can rise to the level of potential that they have. So thank you very much for being here. Thank you all who were able to stay. I know that we lost our quorum, but there was no business that needed to be handled. We maintain our quorum during the business that we had. I got the thumbs up from our council, so we are good. But at this moment, I will adjourn the meeting and thank you all for being here and for your questions. Please be in touch. The meeting is adjourned.